Welcome to Mayor Brown's International Arbitration Across the Pond podcast. Each episode is designed to provide insight on legal issues and other matters affecting international arbitration in the UK, US and around the world. The podcast is presented by two of Mayor Brown's international arbitration partners, Kwadwo from the firm's London office and Charles Harris from the firm's Chicago office. You can subscribe to this podcast on all major podcasting platforms, as well as Mayor Brown's YouTube channel. We hope you enjoy the podcast.
Well, everybody, it's been a while since our last episode, but I'm particularly excited about this one. We have a great guest and a great subject. So just to give a little bit of background before I introduce things properly, the background to this is Chucky has told me many times over many years two things. First, that he's confused by the English system of solicitors and barristers and doesn't really understand what it's for. And the second, that if he practiced law in England, he would be a barrister. And I think the suggestion there is that if you don't do your own advocacy, you're not a proper litigator, but I'll let Chucky explain that more fully. So this podcast, really, it's a chance for me to defend the honour of the solicitor's profession here in England, but much more importantly, it's a chance for Chucky to share what he now knows about the practice of solicitors in England. Because in an exciting piece of news, Chucky is bringing his practice literally across the pond. By the time that this episode airs, he'll be a fully jointly qualified solicitor, both in Chicago and here in England and Wales, because he has been admitted as an English solicitor. Chucky, my congratulations. So it's against that backdrop that we're very pleased and very lucky to be joined by a true expert on advocacy, and that is Krista Lee KC of Keating Chambers. So I would like to say a few things. Welcome, Chucky, welcome listeners, and in particular, welcome, Krista. Are you able to say a little bit about yourself and give us a bit of your background, Krista?
So I'm a barrister. I specialise in construction engineering disputes, based in Keating Chambers in London, and I became a KC in March 2020.
Thanks so much, Krista. So over to you, Chucky. Have you got any ideas for the title for this episode?
You know, so I was thank you for that introduction. That was great, and Krista, happy to have you here, and looking forward to this discussion. And the answer is no, I don't. But you know, when I was so my first, I'll just give you a little anecdote. My first kind of understanding, I guess, of this whole distinction between solicitors and barristers came in an arbitration a long time ago that was seated in London. And we were, you know, we're litigators, you know, so for the hearing, we had a bunch of QCs. We had 3 QCs who were our panel. And the partners, I was a young lawyer at that time, said that, hey, we should get a barrister. And I was like, oh, to do our hearing. And I was like, what? You know, we're not going to do it. You know, we're trial lawyers. But I mean, so the barrister was a gentleman named Chris Butcher. I don't know if you know him, but it was my job to kind of deal with him and provide him the information that he needed. But I don't know that even at that time I still understood the distinction. My understanding was that the partners on the case felt like we needed that because there's a certain way that the evidence is presented that QCs are kind of used to hearing and kind of used to getting the evidence in a certain way. So that was our reason for having a QC at that time who was also going to present our panel. But the interesting thing is that now I see that QC is now KC, right? So when I was thinking about the name, and I understand that this is kind of a historic thing. So now we're back to King's Counsel instead of Queen's Counsel. And we need to figure out a way to incorporate that in the title somehow. I haven't figured that out yet, but a long way to get to. I haven't figured it out.
Thanks a lot, Chucky. So I think that's a great springboard, really, for you, Krista, to just explain a little bit about what a KC is, what a KC does. If you could do that, bearing in mind that some of our audience may not be familiar with the English way of doing things. And also, could you, if you can, give it a bit of an international arbitration context? Where do the skills of the KC really come into play in the context of international arbitration?
And one thing I'll jump in and say before you jump in, one thing is I was searching in trying to understand, getting prepared for this discussion. I saw that there's, I think, 17,000 barristers and 150,000 solicitors. So I want to understand kind of how that happened, and why there are so few of you. So sorry to interrupt.
So I think probably first the first distinction is between solicitors and barristers. And the way I explain it to students who say to me, should I be a solicitor or a barrister, is that solicitors do all legal work. They do transactional work and non-transactional work. A part of their portfolio of services is dispute resolution. Barristers only do disputes. They don't do any transactional work. They don't draft any contracts. And then within dispute resolution, they specialize only in advocacy. They specialize in going to court, but advocacy can be oral as well as written. So that's, I think, the basic distinction. The reason why there are so many more solicitors is because so much falls within the umbrella of legal services, despite apart from just disputes. And that's what I think solicitors deal with. And certainly that was my experience many years ago when actually I did a work experience at Kwadwo, or law firm. Now, as to King's Counsel and Queen's Counsel, you're absolutely right. It's historic. It was a badge of honour awarded to barristers by the King or the Queen. And what it did, it gave them precedence in court to speak. And they were deemed to be the most learned in the law. And so it speeded up the court business. What does it mean now? It's still an award by the Crown. It's meant to be an honour for excellence in advocacy, and not just based on years of experience, but it's quite a rigorous process now. You have to show excellence in written advocacy, oral advocacy, understanding the law. And when I say understanding the law, it's understanding the English law. So it is quite an English-based thing. So then the question is, well, what does that mean? And there was a discussion actually in about 2004 that perhaps we should get rid of King's Counsel, Queen's Counsel. Perhaps it was seen as too elitist as well. The process for getting Queen's Counsel as it was then was seen as perhaps, there were secret soundings amongst the judiciary as to who the best advocates were. And that wasn't perhaps the best process for giving this badge of honour. But one of the reasons for maintaining the system, it was argued that from an international perspective, it gave international lawyers and clients a benchmark to distinguish between those barristers that were excellent. All barristers are self-employed. It's very difficult to judge how good they are or not. So it was a sign as well to international lawyers and in international arbitration as to a badge of excellence that anyone could achieve. And there was actually quite a lobby from those from perhaps underrepresented backgrounds to say, well, we want this system to stay in place, but we can show that we've got this badge of excellence to an international audience.
Right. I like that. I like that reason. And I think,
yeah.
It's important to be able to look at, objective criteria when you're underrepresented. One of the things I wanted to ask is you talked about the process being rigorous. Can you talk a little bit about that process? So you said you went through it in 2020?
2020. I have to say it took a number of years.
Okay.
What you essentially need to do is build up a portfolio of 10 cases, 10 complex cases where perhaps there is either it's a very long hearing, it's complex because of the amount at stake, or it's complex because of the law. And you have to gather references from judges, from clients, solicitors, from other QCs at the time. You put together all this evidence to show that you have the five competencies. So understanding the law, and again, it's English law, which generally means you have to have a Court of Appeal case where you are the advocate. Written or oral advocacy, from a commercial perspective, that's quite easy because we draft pleadings and submissions all the time. Working with others, which is leadership, that you can lead a legal team. One of the, I think, defining features of barristers when you get to litigation. So you were saying, well, why were we going to get a barrister in? I think sometimes, well, my view of it is that the solicitors team do a lot of evidence gathering. And when you come to presenting a case in court or arbitration, sometimes it assists to have a bit of distance. Someone who's taking an objective view is not perhaps passionately allied with the client and can present it in a more clear, objective way. I think that is a benefit to having external counsel. So there is that leadership skills that you need to show. Fourth, which is quite interesting, I would imagine from an international perspective, there is a competency diversity. And you have to show that you understand and respect diversity and cultural issues in dealing with clients, in dealing with cases, and obviously that's important in an international context. And finally, integrity. The bar prides itself on having high standards of honesty, straightforwardness, and your professional dealings. And you gather all this evidence together. You fill in a very long form. The committee then goes and gets references. They pick most of the referees. You can nominate a few, but they pick them. And then you have to have an interview to fill in any gaps in the competencies to provide more evidence. And the panel is, I think it's a judge. I think there are some barristers, solicitors, and the lay people as well on the panel. So that's the process to make it as objective as possible.
Okay.
Wow. Well, hats off to you, Krista, for getting through all of that. And that really is a badge of honor and obviously a testament to your competence and achievements. That's fantastic. One question, and this is really for you, Chucky, if I may, and that is, we've heard from Krista about how on the English side, there are sort of clear badges or distinctions. So on the one hand, you have solicitors who do litigation. Then you've got the barristers who are specialists, and then within that, there's another sort of signpost again. For the benefit of people, both domestically and internationally, showing the true subject matter experts who are the QCs or now KCs. How does that compare to the system in the US? Are there similar signifiers which would distinguish who might be most appropriate for doing trial advocacy as opposed to more general litigation, or in the fused profession, is it more a case that most lawyers will do a bit of everything?
It's interesting. I think that most lawyers, I think, feel like they can do anything. How it generally plays out, and look, I mean, in our profession, most cases don't go to trial. I mean, our client base, they don't want to take the chance of having a jury decide a case, because there's a lot of potential liability there, and a lot of times it's a wild card. So generally, I think most people feel like they can take the case to trial, but what happens is that once you get to the place, and what Krista said about having somebody who was kind of separated from the everyday morass of a lot of these cases, you'll have somebody who is maybe been a U.S. attorney for the government and tried a lot of cases and have been on their feet a lot during their career, come in and be the main person who is trying a case. So somebody who hasn't been necessarily involved in the case in U.S. style discovery for 2 years, but they'll come in and they'll understand the documents that you have, the key documents that you've kind of whittled down these thousands of documents to, and get up and try the case in front of the jury. are in front of the judge, depending on whether it's a bench trial or a jury trial. So there's not, I guess the answer to the question is that there's not a distinction, there's not an actual distinction, but in practice, generally the person who is in front of the court and who's trying a case is somebody who has had a lot of repetitions, like doing that type of trial work.
I see. So we're not both in the English context and in the US, that experience of regularly trying cases is a benefit for those who are actually find themselves on their feet and actually doing the advocacy in the trial. Right.
And it's just, and I found that in my experience, I mean, I've tried a lot of cases, but in my experience, that having that person who's had a lot of repetitions is coming in and giving that objective view at an important time, a critical time in the case is very important and very helpful.
Sure. So back to you, Krista. What I'd like to do for our listeners is look a little bit more at advocacy in the international arbitration context. And I understand that you both sit as arbitrator and also do quite a bit of your advocacy in arbitrations. Is that right?
Yeah, that's right. I do. At the moment, I do a mix of both counsel work and sitting as arbitrator.
Excellent. I think what I'd be interested in is how do you think good advocacy can make a difference in an international arbitration case? And what, if any, do you see as the differences between advocacy before an arbitral tribunal and advocacy before a judge?
So these are things that I have realized sitting as arbitrator about how advocacy makes a difference. Sometimes you can have in front of you two advocates and they're both good advocates, but one is more aligned to maybe the way you think or it just has a more perhaps smooth style, shall I say. I'm someone who prefers that kind of style rather than a more aggressive style. And what I find, I have to listen very carefully. I have to make sure that I'm not seduced by what I may be biased to think is the better advocate. So it definitely makes a difference. And as an arbitrator, I think I have to train myself to listen to actually the substance of what they're saying and who's the better oralist. The second thing I've noticed is that you can make sometimes the best submission you think on a particular application. And then later, because you have the same arbitrator hearing procedural application after next, it becomes a matter of trust. Can I trust this advocate not to be exaggerating or not perhaps be saying absolutely the truth? For instance, I had an application in front of me to amend very late, day one of the arbitration, to amend. And the person opposing the application said, well, this is a late amendment. If the amendment comes in, then I will need more evidence and I'll have to go to my witnesses and get more statements. And so even though the application was late, it wasn't unreasonable. I said, fine, we'll have the amendments allowed and I'll give you a timetable for more evidence. A couple of days later, well, where's this evidence? Oh, we don't need any to deal with it. We can just deal with it on paper. And so, yes, it was a good submission. We could need more evidence, but it's about building trust with your tribunal. So that's the second example of how advocacy makes a difference. And the third area is
Can I delve into that a little bit? I have some questions about that. So in that case, because did you have a certain feeling because they ultimately didn't come back and need the evidence? Because I mean, you could go back and there's a lot of, as you understand, I mean, there's a lot of reasons why you might make decisions, and they could have gone back and said, hey, it's worth spending the money. There could have been a lot of different reasons why they ultimately chose not to pursue that additional evidence.
You're absolutely right, but I suppose there was a bit of background to that.
Okay.
There was a previous application for disclosure, which they had said resisted on the basis that they weren't really talking to these particular third parties who they were then presenting to me. They would need as witnesses to deal with this amended case. But I just think as an advocate, you need to be your integrity has to be high, so that you don't lose the trust of the tribunal. The third thing to observe as a tribunal member I found, which is very interesting, is cross-examination. And you have to be very careful about what your agenda is as counsel. Are you trying to tell the tribunal a story, trying to tell them the facts, or are you having a fight with the witness? And number one is what you should be doing. You should be trying to tell the tribunal the factual evidence that you want them to find. And there are all sorts of tics that I now realize we use as advocates to cross-examine, which are not necessarily helpful, and they're just designed to put off the witness, which in some contexts is appropriate, but in the sort of commercial arbitration I do, it's not generally appropriate, and it can just annoy the tribunal. So those are sort of the three things I've noticed in terms of advocacy style and what you should do with counsel that I now take on board in my own counsel work.
That's really interesting, Krista. We'll take that on board too.
Right.
Do you think there's a difference then between how you'd approach your advocacy in an arbitration and how you would in a court?
Yeah, definitely. I think when you're in arbitration, it's more akin to a business meeting. And the tribunal is concerned with, yes, resolving this dispute, but in a very kind of business commercial world. When you go to court, the tribunal is obviously different, and you have to speak to the tribunal. I would say, as a broad generalization, the quality of judges in court, their training and their rigor in terms of evidence is so high. And that's not always echoed in international arbitration. That doesn't mean that the arbitrators aren't good at what they do. It's just a different approach. And there is this luxury of time in court that you don't have in arbitration. With arbitration, you have got to get through the business in 1 week or 2 weeks. In court, the judge will give the case whatever time it takes. They sit shorter hours. You have to, as a matter of procedure, put your entire case. If your case is listed for 2 weeks and you just don't get through the evidence, the judge will extend the time. In arbitration, that's it, time over. And so I think that a court will expect a more detailed, perhaps, approach, and you have to speak to your tribunal. You have to use the language, the terms, speak in a more perhaps legally sophisticated way, which doesn't apply to a tribunal when we're doing a fine account claim and you're trying to tell the tribunal where the money lies. Arbitrators are far more focused on that commercial aspect of money, and judges often, to be honest, get sidetracked by the law.
What do you prefer?
Oh, I prefer international arbitration.
Okay.
I think, but it's a difference in perspective. For me, the challenges of international projects with international clients is a far more stimulating environment. I'm talking about domestic cases primarily in the English courts. It's very insular. It's just less exciting.
Okay. And when you talk about evidence, I think it was fascinating to me how you described the distinction in evidence. I guess the way you present it to a court as opposed to the arbitration panel. Can you go into that a little bit more?
So with an arbitration, I don't think I've ever been in an arbitration longer than 2 weeks as counsel. I have to tailor my presentation to get the key points across to the tribunal in terms of the key documents, in terms of the expert points and the factual points. And my agenda in that time is to tell the tribunal how they are to approach looking at the evidence when they go off for their deliberations, which are generally longer than, I'd say, than a court. With a court, the rules are such that I have to present to every single witness of relevance all the points of fact that they could respond to. I have to present absolutely every single legal argument. I can't leave anything untouched. I have to be absolutely thorough. And so it is a more detailed process.
Okay. And that is there a rule that requires that? Is that prescribes that, or is that just custom and practice?
I think it's just custom and practice that you have to put every point to the witness, or the other side will run the argument in their closing submissions. Oh, well, Miss Lee didn't put this point to the witness, so she didn't give him the opportunity to answer. And that will be a sort of presumption against my case.
Okay.
So I get a real impression there, I suppose, of the lower level of formality, which is obviously characterizes many aspects of international arbitration compared to courts in terms of it. It's a bit more flexible, takes a bit more time. It has to be, I suppose, a bit more rough and ready in terms of if a tribunal says, right, they'll make themselves available for 2 weeks. That's all you're going to get. And I suppose at the same time, and certainly the impression I get from you, is that calls on a greater degree of flexibility from the advocate as well. Do you think that's true?
To some extent, I think that sometimes in international arbitration, because of the lack of, I suppose, detailed procedure or predictability, it does mean that you can be thrown off key. You can't say, oh, well, this has come in, can we adjourn till next week? There isn't a next week. You have to deal with it there and then.
One other thing, Krista, I wanted to ask about, and say, conscious of the fact that we're doing all this through our webcams, and given that the increase in remote hearings, both in court and in international arbitration, particularly since the COVID pandemic and lockdowns, what are your views on those? Is that something you found a challenge, or do you think it actually speeds up and facilitates the process?
I mean, I think at first there were quite a few challenges with the technology, remote bundles, making sure everyone had good enough connections. I think we've got better at that, and all those teething problems are principally resolved. I mean, you can still have a witness in an odd location, for instance, who doesn't have a good connection. I think that for procedural meetings and in terms of keeping an arbitration on track, having Zoom hearings is great. I can say in an arbitration, we're going to check in every 2 months. I couldn't have done that in the context of always the presumption being of in-person hearings. I think it means that if there is another pandemic, it'll still be business as usual. But I think there is, I think we lose something for final evidentiary hearings on Zoom. I prefer them in person. I think there's a lot of language, that is body language. I think it is of benefit to see an entire legal team rather than just the oralist. I think that from a tribunal perspective, if you're sitting on a panel, it's much more easier to deliberate if you're all sitting in the same room than if you have to sort of switch off one Zoom call and go on to the other. So I think remote hearings are great for managing procedure. It means you can have many more hearings, you can touch base with your parties more easily, but for final hearings, I think it is better. You can assess the evidence when oral evidence is important in person. When you've got, for instance, when you've got diagrams and plans, you can have your expert come over your shoulder and point to you on the drawing, or have a book of drawings. You can't do that as easily on Zoom.
And Chucky, when you're doing your advocacy, what's your take on remote hearings? Are your experiences similar to what Krista's just described?
Yes. So I have done remote hearings remote arbitrations as an arbitrator and as an advocate. And I do agree that you lose something. At the same time, particularly in the arbitrations where I sat as an arbitrator, I mean, I didn't feel like we lost much. And I do think that we should start getting back in person and as much as possible. But I think that parties should consider, I think there's a lot of things to consider in deciding whether you do it remotely or in person. I think cost, the amount in controversy, how many witnesses. I think there's a lot of different factors to decide that should go into the decision of what you do. But ultimately, I think it's great to have the options to do it remotely as opposed to in person, just because I just don't feel like you really lose that much in whatever form you ultimately decide to do it, if anything at all.
Yeah, that makes good sense, Chucky. And one thing certainly struck a chord with me, Krista, when you mentioned that the technology, I think, has really come on and people's familiarity with it really has. So I think, now we've seen it with remote bundles, with demonstratives, with things seamlessly working together, so that actually quite complex matters and quite complex hearings can be conducted quite smoothly, even if either some or all the parties are conducting that remotely.
And when you talk about bundles, I mean, I wouldn't know what that was a couple of years ago. But I mean, one of the good things about remote hearings is you don't have to come to court with 20 boxes. I mean, people don't talk about that. I mean, it's very, I mean, there's platforms now that offer, very, very kind of state-of-the-art technology for putting up exhibits and annotating exhibits and everything. And you don't have to lug all of these boxes in the court. I mean, that, to me, that is kind of the greatest thing about it.
Excellent. Well, thanks both. I was wondering if we could jump on to another subject, and that is, I think, English arbitration is particularly exciting at the moment, given the fact that the Arbitration Act, the 1996 Act, which governs arbitration in England, is likely to be updated. And I think, it's been in place since 1996. So I think it is a ripe time to look at and review how some aspects of it are working, ensure that it is still world-class and supports international arbitration effectively. I just wondered, Krista, if that's something you'd been looking at all, whether there's any areas either that you've heard of that may be changed and updated that you either support or are concerned by, or if there's anything that you would like to see changed, but that perhaps might not be being looked at the consultation at the moment. So let us know your thoughts, and then maybe I'll throw in a few suggestions of my own.
Okay, so there's one area which actually they weren't going to do make any changes to, and then after the first consultation, but there've been 2 consultation papers by the Law Commission on this. And what the Law Commission do is they put forward proposals and then they send it out for consultation. And then there was a second consultation paper on just 2 discrete points because of the feedback they had received. And one of them is the proper law of the arbitration agreement. And at the moment, the Arbitration Act doesn't really say anything about that. It's up to the parties and up to normal, I suppose, conflict of law rules as to what the law of the arbitration agreement is. And the proposal now is that the proper law of the arbitration agreement should be the law of the seat, unless it's otherwise expressly agreed, which is quite interesting because it means you can then have a contract which is governed by a different law from the law of the arbitration. But on the other hand, it makes sense that if your seat is London, that you should get the benefit of the Arbitration Act and the benefit of the very, I suppose, pro-arbitration approach of the courts. And that ties in with another proposal, which is that where a tribunal decides its own jurisdiction, the appeal from that to the court should be limited so that deference should be given to the original tribunal's decision, so that it should be, they first said, the consultation paper first said that it should be an appeal and not a rehearing. They've had to clarify that to say, we want to give deference to the tribunal's decision on jurisdiction. That means there'll be no new arguments and no new evidence. The question is going to be solely whether the tribunal got it wrong, rather than allow the party the second bite at the cherry for the jurisdiction argument. So those, I think, are the two, for me, those are the two most important or significant aspects of the proposed changes.
Thank you. Yes, what you said about the law governing the arbitration agreement certainly strikes a chord. And I don't know if you recall, Chucky, probably back in one of the dim and distant episodes we did on this podcast, but we talked about the Anchor and Chubb Supreme Court judgment here in England, which grappled with that. And I think the conclusion reached by the court there probably for a lot of people didn't quite give the degree of simplicity or clarity, certainly that the sort of default provision which is now being discussed and as you've outlined, Krista, would provide. So I think if that could be introduced, that would actually be welcome in terms of providing clarity. And also, after all, I think if parties do select English arbitration, that itself is a vote of confidence in, and it's a choice for English law and the English courts to provide supervision. And I think it makes logical sense, if it hasn't been stated to the contrary elsewhere, that also extends to the arbitration agreement.
No, Kwadwo is absolutely right, that it was a response to the confusion created by Anchor and Chubb that this proposal has now been put forward.
And I do remember that. On the jurisdiction point, I mean, just my personal view, I like for the court to be able to decide arbitrability issues. And I just think that arbitrators deciding, an arbitrator, whether it's an arbitrator or a panel, I just think that there's often a conflict of interest. So, you know, I would actually be in favor of having the court have probably more significant discretion to decide those issues that it sounds like they're talking about under amendment. So that's just my 2 cents.
That's an interesting take, Chucky. I mean, not concerned about perhaps parties taking advantage of that and kicking things off to the court really as a delay tactic, and therefore that's sort of encouraging parties, and particularly recalcitrant parties who don't want to be in the arbitration to use that as an additional lever to delay and prolong the process.
Well, people. So I have arbitrations now where people have cases in court, questioning whether they're arbitrable, but that hasn't delayed the arbitration at all. I mean, you have to at least here, you have to have something from the court that delays it. So an injunction, essentially an injunction from the court that puts a stop to it. And I imagine it's probably the same thing over there. So I haven't seen somebody filing something to the court actually delaying the arbitration process. And I mean, I don't think that panels or arbitrators generally allow that. It's not, so it's not gamesmanship.
Yeah, I can see that side. So I'm conscious we are probably running up on our allocated time. Is there anything else either of you wanted to raise on any of the subjects we've discussed so far?
Krista, are you happy? Are you happy with your choice as a barrister as opposed to solicitor?
Oh, definitely.
Okay.
I think the first choice is, do you want to do disputes or not?
Right.
And then the question is whether you want to be an advocate. I'm happy with my choices. And the professions are very different here. As a solicitor, you are first employed before you become a partner, and the flexibility of being self-employed, although it's slightly fictional and our lives are slightly run by our clerks, there is a flexibility to being a barrister, I think, and that self-employed status.
And Krista, can I ask you one more question? As a KC, do you have and wear your wigs and gowns, and how often do you get to bring them out, and on what sort of occasions?
I have, for my call ceremony, for the silk ceremony, I got my gowns out. I have got my gowns out 3 subsequent occasions, twice to attend other people's silk ceremony. And third, last week a couple of weeks ago, I attended Adam Constable's elevation to the High Court bench, and we all went robed. So 3 times.
Okay.
Well, thank you very much, and I think you'll be glad that we didn't ask you to wear your wigs for your appearance on this podcast.
Well, thank you for inviting me to this podcast.
Yes, and we'd just like to say how grateful we are, Krista. It's been really fascinating. It's been an education for me. Thank you as well, Chucky. I've learned a few more things about advocacy in the US, which I didn't know before we recorded this podcast. So I really hope our listeners have found this as fascinating as I have. And Krista, just once again, let's like to say how thankful we are. It's been fantastic having you on this episode.
My pleasure.
Thank you, Krista.
Thank you.
We hope you enjoyed this podcast. If you have any suggestions for topics or want to reach Kwadwo Sarkodie or Charles Harris, you can find them at the Mayor Brown website, mayorbrown.com. Also, to learn more about other Mayor Brown audio programs, please visit mayorbrown.com/podcasts. Thank you for listening.